Right, and of course I want to introduce a panelist who are with us this morning to take us through a raft of issues. Of course, the presidential election result is one of them, and also the gender parity rule, which is now back in courts as well. And allow me to introduce to you this morning Gladys Bos-Shule. She is the woman rep elect of Western Gishu County. We do have with us as well Daisy M. Dani. She is the Executive Director of Community Advocacy and Awareness Trust, that is Crown Trust. We do have with us as well Agnes Salome Award. She is the Administrator, Diplomatic Studies, that is Jaramogi Oginga University. Also we have with us Winfred Lichuma. She is the Chair of the National Gender and Equality Commission. Good morning, ladies.
Good morning.
So today is Debarl na Warembo.
Really, Debarl. You really have to say that.
Thank you very much for joining us this morning. Right, let's just begin with this contentious issue that we have today. Of course, until midnight is when now NASA have their timelines to present their petition to court. So far, they've been biding their time on whether they should be going to court. You think maybe the change of mind going to court is good? Even the good Bible says that, yeah, a wise man or a good man changes his mind.
No, I think, Debarl, it's a good thing, because it's one thing to complain and tell the public that you won the election, that there were discrepancies, but the court is the best forum to ventilate those issues so that they can lay out the evidence that they have. The other side can lay out the evidence that they have. IEBC can be able to demonstrate to the entire world and Kenya the processes that they used, and then the courts can make an informed decision. And that way the public can even get to understand it. But if we have one side speaking, it becomes very difficult to know the entire truth. But the court process allows each side in a methodical manner to be able to present their case. Right. So I think it's the best thing that happened. All
right, but in light of what we've just played right now with the Kura Yangu Sauti Yangu, saying that, yes, looking at the entire process, they don't think it was free, fair, and credible. There are many hitches, there are many anomalies that they see, they've observed so far. What will be does this really also throw a wrinkle and, of course, kinks into this whole process? Even if we go to court right now, and of course, they have their own frustrations as well.
You see, Debarl, you cannot just say it was not free and fair. You must demonstrate by tabling the evidence and the arguments before the court that point to the lack of free and fairness. If there were discrepancies, you must demonstrate that this is the result that was actually announced at the polling station, but this is what eventually was captured by IEBC at Bomas. So it gives the opportunity to give the actual evidence, not just speak. It's very easy to make a statement here and say it was not free and fair, but you must be able to demonstrate that in court. So the court process gives us an opportunity to do that, and it's fair to everybody, so that we all understand where they're coming from. IBC also has been accused throughout this process that some of the processes didn't work, or the Form 34s were missing, and so on. It allows IEBC to demonstrate that they were in fact in existence, or they might admit that there was in fact a problem. So I think this is the best opportunity, because if you make a press conference, you don't give the other side a chance to make a response.
All right, let's say from Lichuma. Good morning.
Good morning, Debarl. I think for me, as I said, as we went through the vote, Kenyans have this tendency of being very, very anxious. And looking at the requirement that any person can go to court, it didn't need to be NASA.
Yes.
It didn't need to be NASA. It would have been any Kenyan. So I'm just looking at the relevant article of the Constitution. And even Kura Yangu Sauti Yangu, any of them can move to court and challenge. And again, they have 7 days. So they are well within time. But that anxiety of people wanting to do things immediately, I have not understood it. Remember, even we had the debate around Chepkati, and they kept saying Chepkati has 7 days to announce the results. So he should even have taken his time to verify those forms. I think he would have saved the country a lot if we find a court arriving at the decision to say that some of the forms were not received or otherwise, then we have ourselves to blame because of the anxiety. Now, the Supreme Court any Kenyan can move to Supreme Court to challenge the election of a president, and again within 7 days. So whether it is NASA filing the petition or any other Kenyan, they are very well within their time limit of 7 days. And for me, being a lawyer, I've said this and I'll repeat again, the rule of law must be respected. I think I want to thank any team, because we haven't seen any petition, so we are hoping somebody will go to court. I think that is the right way to go. And the Supreme Court in election matters, especially for the president, acts with the original jurisdiction, and it's final. So I think it has a time frame, which is such a short time frame, and I think if any Kenyan thinks that's the route to walk, I think let's take it.
All right.
Yeah.
So this has been the biggest question. Why were they in the tearing rush to actually, you know, announce the presidential results? And of course, we had so many frustrations coming from NASA as well. They enumerated what they wanted from IBC, but they went full steam ahead and actually announced the presidential, results itself. But the question is, were they really under the gun? Was there anyone prevailing under IBC to make the announcement? Daisy?
Well, you know, Debarl, all we can do is speculate, because I don't know. But that is a legitimate question, because I think IBC, even in the interest of fairness, should have at least addressed concerns coming from a major stakeholder. The fact that they went ahead to announce could mean either that they felt that the issues that were being raised were not sufficient enough to delay, or that they had completed the exercise in accordance with the law. And that is why they chose to announce it. And because they had several meetings, I mean, we watched every day. There was a meeting of agents and, you know, meeting of key people from the different political parties and stakeholders. So I imagine that they would have announced on the basis of having dispensed behind closed doors with those issues, and found that as for them as an electoral management body, they had done their job and they had done all that they could do. Because let's not forget that there was the court case that talked about that ruled on the matter of where the constituency being the place where the presidential elections were announced. And all the returning officer did, or the presiding officer did, was simply send the results to the tallying center. So even if there was an anomaly, the court already ruled that anything, if there was an anomaly, IBC at the National Tallying Center could not make any changes. So even if there was a problem, the only way to open it up is by a court order. Okay? So even if, let's say that the information that was coming to Bomas had discrepancies, the place that you lodge your complaints was actually at the constituency, you know, according to that judgment, not at the Bomas Tallying Center. So there's very little that the guys in Bomas could actually do in terms of addressing any anomalies, because the law says that the anomalies should be addressed where? By court. If you find that there are any discrepancies with what was appearing at Bomas, the only way that you could change it was through a court order. So I think that it's a catch-22 situation. Here you have a situation where people had a problem with the results that were being declared.
Yes.
And that were being displayed at Bomas, but there's very little. Chebukati's hands were tied by the law. So the judgment that came from the appeal court.
All right, we have legal minds here, we have the constitution here. We will actually try and see where Chebukati was tied by the law.
Can I say something?
Yes.
I remember on the day of the announcement of the presidential results, we were at Bomas from in the morning at around 10. Yes. The Prime Minister was called. All the church elders were called. The church leaders were there. They had a meeting. And Chebukati, the ODM side, the NASA side, presented what they were talking about. The NGOs presented what they were talking about, the anomalies. And Chebukati strongly told the group he has heard what they have said, he's going to think, and he's not going to do an announcement. As I was coming through Uhuru Highway, I was shocked. I saw the presidential motorcade coming, and I told myself, tumechezwa. And I was so shocked when it was announced that he's going to give a press conference. We didn't know he was going to announce the results. And this tells you there is a problem. He might have been under a lot of pressure to announce the results because Kenyans were anxious. But I don't think Kenyans were anxious for the results because they could have waited until Monday. That was the deadline. They could have waited until Monday. And you saw what happened on Tuesday. Ezra said they have not received all the Form 34s. So what is it telling us? There was a pressure somewhere, and they would have said, no, let's get everything right, and then we announce the right thing. That could not have caused the deaths of what we have seen, the baby Samantha, this young girl in Mathare. The deaths could not have caused if we just were patient enough. And so I want to say that as much as we say Chebukati was under pressure or he did the right thing, sometimes listening is a gift. And we don't listen enough, and we are not patient enough as a country to wait. Because there's joy in waiting.
All right, there's joy in waiting. Let's say from Gladys Bosrele, because also you were, I think, the SMAC Deb of the IEC then, of course, you know, matters election and, of course, the electoral process itself. Having not presented the Form 34Bs that we are given to understand are still trickling in, how does this throw, you know, the entire process in the light? Is it credible? Is it fair? Because I think they should have gone in tandem with the result, isn't it?
Yes, I mean, the thing about this is, Debarl, is that there's so much that's being said in the media and so much back and forth that we don't have a proper chronology of what transpired.
But we've had admission from the CEO himself that, yes, they didn't have the Form 34Bs. Isn't that credible enough?
Yes, it should be credible enough, yeah. But, and that's why for me, I'm looking forward to actually the election petition before the court, because then this can be put forward. Because this is how it, I mean, we assume, IEBC has a process. Usually, the results will come from the polling station and they will go to the constituency level. From the constituency level, they will be moved to the Form 34B. And when that happens, the announcement is made there. Every party and every independent person will have their agents present there. And the agents will listen to the announcement. They will normally record it. The agents will ask to take even a photograph of the form. That's what my agents did. Even if they didn't have a copy, they took a photograph of it. So you should be able to compile that and be able to say this is what, and confirm that the result that is being announced at national level, if it's presidential, is the correct one. And that is, and in the case of someone like me, I was confirming that at the county tallying center, the result that I received from my agents from the ground is in fact the same one that was being announced. They may, and so what I would like to see is a situation where they say that in this particular constituency level, this was the result that was announced. This is the result that is supposed to be on the form, but this is what was announced at Bomas. What happens is, if there is a discrepancy, that becomes a point of argument during the Supreme Court hearing. And that is why it is a great opportunity for Kenyans to have a methodical interrogation of what was done wrong or what was done right, and whether it is in fact affects the final result. And now that you're saying, all of you, and I like that Salome has said patience is important, let's be patient. Because already NASA has announced, yes, through their party leader, that they shall go to the Supreme Court. They have until today to file the matter. And midnight, I think. And so what will happen is, I'm looking forward to looking at that petition. Then let's read it. Then from then on, and then we'll have another 4 days to receive to get the response from the other side. And I think that is when we can start having a more intelligent conversation about this. Because I think discussing it otherwise is, yeah. And I mean, I always tell myself, sometimes I don't pay too much attention to the press, because they take parts of someone's statement, but probably, you know, not the whole part, so it doesn't make sense. So I think this is let's ask Kenyans to be patient and watch the Supreme Court. And I think, like we saw last time, it's public. It will probably be live on all the media houses. Let's all be vigilant as Kenyans. And also as political leaders, as opinion leaders, as members of the civil society, whether it's Sauti Yangu, Kura Yangu, I think what they will do, this is their opportunity to now watch that the process is properly explained within the court process, and it will be our responsibility to break it down to Kenyans in ordinary language.
All right, we want also to explore the issue of 2013, because we're in the same space, right? We're in the same space, and of course, NASA, they have the bugbears and fears that are the same that happened in 2013. It will be a repeat of maybe what will happen right now. We had the statement from Raila Odinga saying, of course, this is now time for you, the Supreme Court, to redeem yourself, because you are leaning on one side the other time. Looking at, of course, this is just looking at the crystal ball and the constitution of the Supreme Judges as well. Do you think NASA has a valid concern when they say we wonder if they'll get justice from the Supreme Court?
I think all of us, if we are law-abiding Kenyans who respect the Constitution, will always know that, I mean, we will assume that the Supreme Court will respect the law. Remember, the Supreme Court can't just make a pronouncement, isn't it?
Yes.
They have to say that these are the facts presented before us. This is the law that is applicable, and when that law applied is this outcome, and this is the legal position. So it's not from their own whims or how they feel about it. And that is what we'll be watching. The only time you can interrogate a decision of the court, it is when it is the decision is made completely outside the evidence presented and outside the law that is before us. And there are many great lawyers in this country that can interrogate that. And there'll be many lawyers to raise those issues. Yeah, but so let's give them an opportunity.
But the panelists are saying that, of course, the Supreme Court then was a lapdog of the executive.
But on what basis would you make that decision, that judgment?
Yeah, this is what the panelists are saying, of course, and we just give, you know, we do not know what really happens behind the scene. This can really not really come to the fore.
And I think that's when we need to ask for fairness. Just because a decision does not come out in your favor is not sufficient to say that the Supreme Court was a lapdog of the executive. I think what we should be looking at is we should have had legal minds interrogating the judgment that was delivered by the Supreme Court. Right. They gave the order immediately, but thereafter they had a detailed judgment. A judgment is the reasons for reaching a certain decision. So we should look at the reasoning. If we think the reasoning was not sound, we've had 5 years to debate that, to discuss that issue. And I mean, people make legal writings relating to it and so on. And so we should be, that is what we should be interrogating, not just making a statement in itself.
All right. Let's say from Agnes, or welcome to you, Agnes.
I have been a judicial officer.
Yes.
Albeit at a lower level. And I'll tell you, for any decision you make, you have a loser and a winner. Unless parties are consenting, there is no way you will have a ruling or a judgment that pleases all the parties. And again, in the spirit of not speculating, I think 2013 was 2013. I want to think and imagine that the evidence that the team then had might not necessarily be the same evidence as what now they are going to present. And a lot of reforms have gone into the electoral process and system since 2013 that I think puts Kenya at a better position in terms of the evidential credibility that is required to prove the case. The only thing I think I never did, and which I would want to urge our seniors not to do, is to say, this is the way the ruling is, we shall give reasoning later. I think for me, it is that let's take the time, let's burn the midnight oil, let them look at the evidence, and let them give us a well-reasoned judgment, because they are final at the end of it. Yes. The only thing in 2013 I was taken aback is to go the direction. I know the seniors used to do it in the High Court, even when I was a magistrate. But for me, I never released a judgment or a ruling to say this is the way it's going, I will give the reasoning later. I think Kenyan are patient enough. We tried to have the time expanded, and again, the 11th Parliament did not want to open the time frames. I remember now the current Chief Justice headed the team of reforms. And I sat in all his meetings. And his call was that, colleagues, the time frames given within 14 days is very short. You cannot give a you cannot have both parts make the argument. And even remember, there was this long affidavit that was expunged, I think, from record, because the time frame could not allow them to put the documentation together. But the 11th Parliament did fail us because that time frame was not provided. But whichever way now we work with the time frames that are within, I would want to urge the Supreme Court that they need to really ban the midnight oil and give us a ruling or a judgment that is accompanied with the reasoning. Because you see, the anxiety will end when you say, we think it was fair, we'll give reasons later. And if you remember, the reasons came, I think, after like 3 weeks, 1 month after the declaration. So I'm quite confident that right now we also even have changes in the Supreme Court. We have new blood that has come in. And for us to have chosen the 7 men and women to sit in the Supreme Court, it means there is something as a country we saw that they can deliver. And I think let's just trust that they will do the right thing.
So are we facing the same timelines, that the 14 days, or same timelines?
Same timelines.
So will we still have the same issue? If maybe they come with the bulk of what they did have, I think even them they were doing, they're presenting also the evidence, under the wire, last minute. We have now a colossal amount of Form 34s and other issues that they do have, maybe even the database from IBC. Still, 14 days you think is likely to be sufficient?
Could I just say this? I think Debarl also, and this is something I would appeal to the lawyers involved, because also what happens is, and I used to say this to my students when I taught civil procedure, when you're filing a case in court, there are some things that you file in and you look like a great lawyer and it impresses the general public, but may not necessarily be important for the actual case. So one of the things each of the parties should be asking their lawyers is to put in, if they just file only the documents that are relevant to the actual decision that they're seeking from the court, the documents won't be so bulky, and to be able to make the judges very focused. If you look at the 2013 petition, there were things about procurement, which really doesn't affect the outcome of the election, because here you're looking at it and saying, if you're talking about discrepancies, talk about a discrepancy that was most likely to alter the outcome of the election. So stay focused on the way you channel your case. If the lawyers are disciplined and true to their profession, then the 14 days is sufficient. But it is not a chance, it's not an opportunity for you to throw every complaint and every issue that you want. Some of the issues we raised were issues that are issues of amendment another time. So I think if we are disciplined, it could happen.
All right, let's hear from Daisy.
To be fair, to be fair, I think the judiciary has been preparing for this moment. And we have heard them time and time again speak about their preparedness. They have been preparing for and anticipating that they would have to deal with a petition of this magnitude. So of course the judiciary itself also understands what kind of issues that they would be dealing with, and the bulk of documents, because there are some of them, when you talk about the bulk of the form 34s, how many polling centers. So I imagine that in part of their preparation is to put in place a team that would be able to comb through the evidence, should they bring all the bulk of evidence. So I think, let's be fair, let's not try to preempt, based on the failings of 2013, because very many people were disappointed with the way the Supreme Court...
But we need to learn from the failings as well, so that we don't have a repeat of it when it comes, that
aside from us learning from the failings, that the Supreme Court itself has learned from their failings, because there have been people have interrogated the decision that was made by the Supreme Court and expressed their dissatisfaction. In fact, I believe one lawyer, Washira Maina, wrote a very lengthy article about how the Supreme Court actually failed us in 2013. And remember that the world is watching, and I want to believe that the Supreme Court judges understand that Kenya is watching, the world is watching, and that they are setting precedent, not just for us, but also a judgment that can also be cited elsewhere in the Commonwealth. So I want to believe that that they would have the best interests of the country at heart, and that they will, render a ruling or a judgment based on the evidence brought before them, and as Lichuma has said, that it is well reasoned, and that we can follow that judgment and see that due process, and that they have been fair in the way they have executed their judgment. Nothing else will suffice, because then they will go down. Because I remember after 2013, a lot of people said, these guys are letting us down, maybe we should do away with the Supreme Court, because they are final. Right. And you don't want a final rendering of something that doesn't make any sense, and leaves people with more questions.
And the place of
than
Supreme
answers.
Court has come to also to be questioned as well, if we really do need the Supreme Court as well. So the issue you've raised is very key. Yes, we had issues with the Supreme Court. People now expressed their frustration with the Supreme Court, but we never talked about this until now. Still, we're coming to the fore with the 14 days, window period that we've been given in the Constitution. That will be another subject as well. People say this is not a sufficient time to actually express our frustrations and file our petitions as well, and the due process to take its course as well. Agnes?
I think I've been raising my hand way too long because there's an issue burning in me.
Okay, sorry.
I just want to face the judges who are going to be in the Supreme Court. I don't have any doubts about our Chief Justice. He's a man very straightforward. He knows what he's doing. But those judges, I want to tell them, as my sister here said, Kenyans are watching you. The world is watching you. When you go to that room, remember, you are doing it not for yourself, not for somebody, but for this country, for the generation that will follow you, for your own children, and for justice in this country. Let justice speak. Let truth speak. And as they said, when you give judgment and delay the facts of judgment, then people question, was this judgment proper? Just like we are questioning, was the announcement of the presidential election at the right time right now? So I hope they will take their time. They'll burn the midnight lamp, as our Chief Justice has said, to give Kenyans what is true. And Kenyans are a people, if you say the truth, they'll accept it. It might be painful, but that's the truth and that's the reality, because it's backed with facts and it's backed with justice.
All right.
Thank you.
All right, and of course, we want to take a short break right now. It's 7 on the nose. So when we come back, we want to explore the issue of a 14-day window period that we do have, but still in the Constitution. That was a contentious issue with the Supreme Court last time. Of course, people were expressing their frustrations as well. So do we have, as Kenyans, that latent concern to actually explore and probe these questions that were raised by so many questions, so many Kenyans, I should say, during the 2013 general election, that we swept them under the carpet and we never probed the issues. Now they're coming to the fore. So are we remaining always none the wiser as far as very ticklish issues are concerned in this country? We explore that on the other side of the break. Don't go away. Much more coming up on the other side of the break. Daisy and Danny. So before we took a short break, I think I've lost my track of thought as well, because I went to the gender parity rule, but we're still on the presidential election result dispute as well. But the question that is really coming to the fore right now is the issue also of, I don't know if we've really exhausted with the presidential election result. And should you have any comment, please? You can take the stage right now before we drill deeper to other issues. I just
want to say that IEBC actually on the election day did a very good election. They have to be valued and to be thanked for what they did. Yes. I was a chief agent for NASA in Nairobi. I worked very hard. I saw the processes. I went into the halls. The process was very well done. We have to congratulate them. The only problem is when it came to transmitting results. But IEBC did a very perfect job. And Kenyans came out in all numbers. This is the election, I think, that Kenyans voted in 80%. Everybody went to the polling. And so what we are saying, these presidential results, there's nobody making noise about MPs, governors, everybody. But the presidential results, we really, as Kenyans, and as the judges that are going to take this to the Supreme Court and going to make judgment, have to be very careful. It is very crucial, it's very important that justice stands. I will say that over and over again. Thank you.
All right, but I want to... Yes.
Whichever way, I think both parties, let's accept the court's verdict. I think in Kenya, what we don't do, we don't prepare for failure. So I think what I want to urge is that the court will not have both parties winning.
Right.
There will be a winner, there will be a loser.
Right,
and as even we move to court, let's also help our supporters to accept the verdict of the court.
But we win with
fairness.
Judgment.
Yes.
Right.
You know, because even if the judgment may not be in your favor, but you can see that it is well reasoned and well thought out, then, because you see, in any contest there are winners and losers, but when you know that you lose fairly, then you accept. It is when you feel that you have been denied victory or you have been cheated out of a victory that it brings that, you know, that bitterness. So even in judgments, you want a judgment that is fair, well reasoned, that everybody can see, enyewe, that's a fair judgment. You know, and that's what we're asking for.
Right. It's good also, I've just remembered from where we left, because I was talking about the 14-day window and looking back at 2013, issues that we glossed over, that now they're still facing us as well. While we remaining none the wiser, we may reflect back to 2013 as well. We in the same spot that we were before. This 14-day window period, why has anyone not really challenged it?
It has been challenged. Lichuma spoke about it. And
You
in
did?
fact,
I
yes,
missed it.
yes, Justice Magara, when he was in the president of the appeals court, actually said that that was a short period and that we should consider actually extending it. The matter was brought to Parliament, and this is where we really need to look at how our legislators behave in terms of putting in place legislation that secures processes.
Right.
And I think that the 11th Parliament has failed us on, actually failed us on many fronts, you know, and this is one of the fronts that they failed us.
All right, so the legislation still remains as it is? No, the actually 14-day window period still remains. So why was it not actually, why did it fly in Parliament? What was the issue? I can't really remember this particular discussion.
What happened is that after the election, there were many processes that were looking at electoral reforms. And the judiciary constituted a team that was chaired by the now current Chief Justice. And they did a good job because they invited the majority of institutions, lawyers, the LSK and the rest to look at the time frames. And what the 11th Parliament did, and what I would want to urge the Chief Justice to bring sanity to, we were not sure who the originator of bills was supposed to be. So that most of the bills that emanated were either private members' motion or the leader of majority. So that the AG's hands were not full in terms of being the person who presents the bill. So what happened is, amendments that came in from IBC were quickly put through by the leader of majority and were discussed. By the time now the other considerations from the judiciary were being proposed to come into the amendment laws, the ones by IBC had already gone through. So the consideration of the extra proposals then did not make it to the House. But number two, I think we also cannot remove the Charles Nyachaya team from the hook. Because they were supposed to look at the Constitution and tell us its viability. And for you to trigger an amendment to that section, you required a constitutional amendment. The same thing to the two-third gender rule. And I think as Kenyans, we have to tell ourselves we have a very good constitution. But there's some of the sections in the constitution that must really be looked at. And if you asked me, that is one of the sections. So the amendments that came would not be accommodated within the Election Act because you must trigger an amendment from the Constitution. And there wasn't time for that constitutional amendment to go through. So the good proposals that came in from the judicial team that thought we can do things differently, and they suggested, because they had gone through the exercise in 2013, and they were better placed to tell us this can work, this cannot work. But somehow we never just go to listen to them.
Yeah, and I think Lichuma, you should be happy to hear this. One of the strongest motivations for me to want to be in the National Assembly and not anywhere else, not governor, not in Senate, was because of exactly this problem. That we don't have sufficient legislators in the National Assembly who want to drive certain bills because it's the correct thing to do. Either they get involved in bills because it's a wave, it's a party position, or it's the politically correct thing to do at that time. But no one is academically looking at the gaps within our constitution, within our laws, in order to push it. You will see that I will spend a lot of time with members of the civil society, with members of people who write articles on what's wrong with our laws and what laws need to be passed, and I'll go and stand in that same gap to be that person who pushes bills like that, where the Attorney General is not doing, is not doing it, will make him do it. So I think it's just that we didn't have people with that drive to do it. And it's one of the things that frustrated me personally. Yes, we know something should be done, we sort of ignore it, and no one is passionate enough about it. Yeah. So you have me now, so you don't have to worry about it.
We said it on national TV. And the first bill that we want to see is the one on the gender rule.
Yes.
And
that we are holding.
Oh,
you.
fantastic.
I hope you will not be sunk in.
I hope you will make them see sense.
Yes, let them see sense.
I always believe that, of course, it doesn't take only just one person for any legislation to
build a group around
but the fact that you have made, ensure that it is tabled and it's come on the floor of the House, it takes a lot more mobilization by members of the public to ensure that they sort of put pressure to bear on their members of the National Assembly in order to push something. So I mean, everybody has a role to play. There are those people who will lobby. There are those people who will put pressure on their members of the National Assembly. I mean, it's days we've done this before. Field phone calls and beg them to go to Parliament on that day, you know. So yes, there is. I think we can do more mobilization. Yes. And
all right. As a wording
and so that even if it fails, it's clear to the people that
I
did make an attempt.
Yeah,
yes,
somebody did
it wasn't
something.
because of that I didn't try. Yes.
Thank you.
And of course, we'll be playing this clip just to remind you.
Yes.
Holding you
Don't worry, I don't have to be reminded.
All right. But tell me, before we wind up on this, then how does this 14-day window period throw a kink and a wrinkle in the entire process, if it goes, and then we are actually strapped with that time?
You know, I think, I always believe this, people can work within whatever timeline you're given. The 14 days is tight, and we discussed it. But here we are still stuck to 14 days, we didn't change the law. And I know something.
Exactly.
The Supreme Court knows that they are stuck with the 14 days. They know the challenges they had last time. They know where they probably didn't use their time more efficiently. They know what to anticipate from the lawyers before them. I think it was that last time. It was the first time. It was the first time that I ever sat in such a case. I believe they are wiser now. They've learned more lessons, and I think also the lawyers who are going to present the cases from all sides have also had the opportunity to review what transpired. And I think it will be a more efficient process. I will also see that the pretrial process that they will have, because remember there is the submission of the petition, and then the response from the other side, the reply, and then there'll be a day that there'll be a pretrial conference. The pretrial is the discussion of how to conduct the rest of the case efficiently and in the shortest time possible. I think the Supreme Court is much wiser. And so they'll be very clear in the way they advise the parties. So I think we have a better chance now. I think it makes sense. You can only improve.
We can only improve, but and we also as a country caught up with this notion that, accept and move on syndrome, right? We don't really delve deeper into issues until now. When we are faced with the same issues, when now we say, okay, the 14-day window period is still here with us, we've not dealt with this. But why should we be flying with the accept and move on before probing deeply into issues?
But that's why we're saying we don't have enough leaders who want to resolve a problem. They talk about it when it's hot and a big topic, and then they forget it.
This is
and
where
if you
maybe
remember when
society...
I was on this show, Debarl,
yes,
I said the same thing. I said, why is it that in 2017, late 2016, we were trying to remove the commissioners or trying to complain about the management of IEBC? I said we should have immediately embarked on that issue in 2014, soon after the election, if we had a problem. If it was an auditing of the register, we should have embarked on it. So we have this problem of doing things last minute. Let us hope that this time, any problems that we think we have, can we embark on them immediately?
Fantastic. Yes, sir.
Just a minute. I would like to say that thing of saying always we move on. Kenyans actually don't move on. We get stuck until another issue comes. That's why we are talking of the same issue, which could have been sorted out immediately after the 2014. 2013 elections. We will, even right now, we say, okay, elections are done. Let's move on. Have we really moved on? We haven't moved on. We are still stuck.
All right. I want to draw your attention also to what the Star has today. And this is it is on the smart screen as well, CK. IEBC plans electronic voting in 2022 polls. That is what we have on the front page of the Star today. Isn't it the syndrome that we're talking about? What we would want to hear is, do we have, you know, a comprehensive report of what happened with the electronic transmission within this particular election that we just had, before we talk about 2022? Yes. This is the accept and move on syndrome that we're talking about, Daisy.
It is. Well, you know,
it is true.
I agree. It is the accept and move on syndrome. And IBC, before they take us to 2022, we must resolve the matters of the electronic transmission first, even before we go into electronic voting.
Yes.
Because even where we just have transmission issues. So let's put it to rest. Remember that IBC have a responsibility. They are supposed to give us a report 3 months after the elections, where they are supposed to give us a full report on the entire electoral process. We know that we are also going to be getting, you know, observer reports, and a lot of the civil society groups that have been part of this electoral process will also be giving their reports. And we hope that now that we have people like Gladys in the legislature who have committed themselves to actually working towards improving Kenya, that we will actually see the necessary legislation and or corrective measures that will be put in place so as to be able to secure the 2022 elections. Because I think that for every election, we actually should be seeking to make it better and better. I have no qualms about electronic voting, but you know, one of the biggest problems, even as we move on, is we also need to start thinking about our software as Kenyans. You know, we're always thinking about systems, hardware, you know, but the systems are only as good as the people who operate them, you know. And so you can have a very good system, but if you have people who are willing to be compromised so that they, at the end of the day, also compromise systems, then no matter what kind of system you put in place, you're not going to get the desired outcome. So even as we look towards putting in place systems that will make our processes better, we must also look inward as Kenyans and begin to have a conversation with ourselves about our national character as people. So even when you talk about that accept and move on syndrome, that we will not be so quick to accept things, even in the face of it, that don't look right, but we delve into it and exhaust those issues to the extent that everybody feels that yes, now we can move on, having addressed the critical issues. And it's not just a problem of people who feel that they have been, you know, cheated out of an election. It is so many issues. We have very many underlying issues that we have not addressed as a nation, you know, in terms of our national character as a people, our national values and principles of governance. And these are conversations that we must have, because when we had the problem in 2007, we said the problem was because our constitution was bad and it was very exclusive. But look, we have a new constitution. You wouldn't believe it. When you look at the way Kenya, the way we are, you cannot believe that these things are happening under a new constitutional order. Likewise, we still have the same challenges that we've had when we had Mlolongo voting. You know, we've put in systems, we've changed commissioners, but we still have the same accusations that we had when it was Kura ya Mlolongo, when it was ballot stuffing, when we didn't have transparent boxes. We're still facing the same issues. So the question that we must ask ourselves, is it about systems, or is it about the people who are managing these systems? Because really, at the end of the day, we need to be able to have processes that have integrity woven into them, because we as a people enshrine the basic principle of integrity. We shouldn't have to have backstopping of everything, that because Gladys is the returning officer, I must have 100 agents there to secure my vote. We should be confident enough that Gladys will do her job as set out in her TORs and according to the oath of office, so that we don't have to keep second guessing, checking. There's so much, we have so much distrust among us.
I just want to
distrust among us, and I will pick up on that. Let's hear from Agnes.
I just wanted to add on integrity. I think she has spoken what Kenyans need. I believe we don't need to go to Al-Goromar, was it called Al-Gurai, to print for us ballot papers. Those could have been printed here in this country. That shows the level of mistrust that we have in this country. That shows the level of integrity issues that we have in this country. And I think the first cause that everybody should have in this is about integrity and trust. We don't even trust ourselves with our own skin. To be very sincere with you. Because if we trusted, do you know the electoral process would have been done like the way they do in the US?
Yes.
I think to follow up
yes.
on, I'm just saying that I think both Daisy and Salome have asked a valid question. I mean, do we need another system for us to trust the electoral system? I think the answer is no. If we go by the best example is Australia. Australia, they do not have voters' cards. They do not have electronic register or biometric recognition of your biological features. They don't have that system at all. You show up at the polling station, you give your address, your residential address. They look you up on the register, they cross out. It's manual. Yes. And yet, they don't have any complaints on the electoral system. So there's a problem with the very fiber of Kenyans that we think if we have another system, our electoral process would be trustworthy. That said, when you talk about IEBC will go, I think IEBC should stop telling us that. That they will go electronic in 2022? No. One, they are the same body that told us that they didn't have network coverage in a high percentage of the polling stations. So then how do you employ electrical systems? Number two, we know that we don't have electricity in all the polling stations that we use, just electricity, or even capable of deploying, so there's a lot more that needs to be done. So before they tell us that, one, they must first review the successes and failures of this current system, and then seek to improve those systems, seek to change the legislation that is in place in order to improve that system. And number two, by the time you go into electronic voting, a lot of voter education has to have been done. And you must know that I think the biggest failure, as I can say it now, of IEBC was voter education this time round.
And that should be the splash on the front pages of the dailies.
They failed on their
civic education is what we will do.
People are not remember.
In the lead up to
Civic
2022.
education was one of the things that took a hit because in December, on the 12th of December last year, the president said Kenyans don't need civic education. He said Kenyans understand the process. So these are the things that some of the things that we need to start
education. And to just finalize on that, you need to pilot a system. If you remember that what is being used now as the biometric, biometric recognition of a voter when you appear at the polling station was first piloted in 2010. When I was at the Electoral Commission, we piloted it in 18 constituencies. And we had used it during by-elections and in the 2010 referendum. We still didn't think it was good enough, and you'll notice that the equipment that was used in 2010 is not the same equipment that was used this time round or used in 2013. In 2013, there was an improved system that was used. And by 2017...
An improved system that failed.
Yes, that's what I'm saying. It takes a process. And so what IEBC should be telling us is how they will phase out the piloting of this voting process in order for them to be able to succeed. So 2022 for electronic voting, no. And if we are so distrusting already, remember Kenyans want to see the ballot paper. Yeah, because that's how we count.
Yes.
This ballot paper, Gladys. So and so this
I
is
actually don't think that is entirely true. Listen, we used to say people wanted to see money. These days, guys transact M-Pesa. Billions of shillings flies through the air.
But it was a process.
But it is because it was made easier. Nothing stops us. I mean, we can even vote with our mobile phones, but do we trust that? Do we trust that system? It goes back to...
Do we have the infrastructure?
We have the infrastructure. If we have the infrastructure to transact, mobile money, where we are sending, millions of shillings across the air, and the bank will not send 10 shillings to me, and it arrives as 100 shillings.
But no, we need to look at the entire system itself. It is between you and the telecoms, provider. So it is two parties. But in the entire process, there are so many stakeholders involved that we don't trust them.
The main party there is IEBC because they are the body that is constitutionally mandated to carry out the elections.
Okay,
so
this is slightly different days here, because in transacting money, it's between you and someone you're sending the money and the service provider. And if there's a problem, you have ways of recalling it.
Yes.
I think with elections, the danger is that the recall system may not have the impact that you want. But also remember, look at our elections. From the polling station to the ward level, we don't have too many disputes, because it's between the polling station and the ward, and you announce your MCA. So there's less complaints about that. Then when you get to the constituency level, yeah, from the polling station to the constituency, for the MPs and whatever, there's a little complaint, but a little less. But when we move from the constituency to Bomas or the National Tallying Center, the problems begin. So you can see that maybe we've perfected from the polling station to the ward level, isn't it? Yeah. And probably to the constituent level to a great extent.
All right.
So we should be asking ourselves, can we improve the systems to the next?
Is it about the systems? It's not about the systems. It's not about the systems. It's about the people.
Fantastic.
No, it's not about the systems.
And one final issue.
Let me just explain. When people were voting, we were told very well, they will be transferred electronically. You scan, and the scanning machines were there. I went as an agent. I was seeing the counting, and even the returning officer would put the number and say, we are now sending, send. So I'm wondering if today we still don't have those forms, where were they being sent?
Management of election.
Yes.
Yeah, we need to wind up on this, because we haven't even broached the subject of gender parity.
Let me say this. I think as Kenyans, we tie ourselves within time frames, and sometimes we don't want to listen. Allow me to say this. And I appeared before the Orengo-led team that was trying to find a way forward for IBC before the commissioners, the former commissioners, exited. And I did make a presentation which is still in my files, because it was written. And I'm talking about time frames that we set for ourselves that sometimes we see cannot work, but we insist. I did appear before this committee and I said, very well, you may have reasons for removing the IBC commissioners, but serving in a commission and having been a pioneer of creating a commission and seeing how commissioners come in and understand the role and execute it, we might be overexcited about having a new team and having elections in August. I did make that presentation, and I will tell you, I was very unpopular. Because we had set our minds, we wanted to have an election, the election was to be August, and the person to hold the elections could not be the former commissioners. So even at the point when we replaced the team with Chepkati, I need to play a devil's advocate for the Chepkati's team. 6 months. She was in the former body. And I think she will tell you, they have really tried in terms of what they were able to do. Because it takes time for you to understand the role. The laws, the electoral laws are many, the rules, the guidelines. Right now, the next battle we are taking to court, maybe today or tomorrow, is the nomination lists. So, I mean, election has many things that if in future, as we rightly have said, we need to get the process right 2 years to the election. And this, I think, Rikla told us, that you cannot expect to make last-minute amendments to processes that will deliver a credible and free and fair election. So I think for me, as we wind on this, it's all about the timeframes we are setting, and we make them to be one that even where there are changes, and some of the changes can be through acts of God.
Yes.
That we then can never go back to them. You are going to go to Parliament. I hope that we can look at this thing reasonably and make decisions that help us move the country forward, as opposed to just keeping on going round in circles.
And as we close this topic, I think it's important to commend IEBC that they did learn from their lessons of 2013. If you look at the 2013, the biometric kits failed, but this time they worked perfectly. I think that is one, so it just shows that they did learn a lesson and improve. on that particular. The operations were very well run.
Right.
In fact, the complaint we are only hearing now is about tallying, but no one is complaining about the actual processes. The lines were short, people voted efficiently, people were detected immediately they got there. There weren't many people turned away from the polling station. In fact, a negligible amount because we didn't hear about it. So I think we must commend them that they did a good job.
Right. And Daisy did talk about this distrust in this country is the issue of trust. And I think a few months ago we had also Chris Musando, the late Chris Musando, on this forum, and this is what he raised when we were talking about the electronic voting system itself and its credibility. He said the issue is not truly the system itself, but the people. Just what Agnes is saying, the people. And what he actually requested is that we take cognizance of the fact that the electronic system itself should actually be a national critical infrastructure. You have been in the IEC, and I think you did a sterling job. We've never had the issues with the IEC so far, so much as we've had with the IBC. How comes we've never really thought about it? Because I think this is where we're headed to. A national critical infrastructure. For the sake even of his soul, I think we should consider this. If we are going that way, fully implementing the electronic system, which people also have misgivings about.
I think the thing is you'd have to undertake a survey, and it's not just the IBC that would do it. I think you have to work with service providers like the network infrastructure. You'd have to talk with the national, the Kenya Power and Lighting, whatever, to know. But also, and then know where places that you need to deploy solar. I know that we learned big lessons. In 2010, we had, when we piloted the 18 constituencies, the biometric kits, at that time, we thought that we would use solar in some places. And then when the solar panels arrived, I think they were so huge that no one could carry them, you know. So, there are things that you don't anticipate. But after that, we learned that we needed to see the equipment and test someone carrying it, moving from place to place with it to register voters. And that's why today, the other day, I was very happy that they had a little one that was like a tablet. So I think slowly we give ourselves time and we draw the roadmap of where we want to go and go step by step. I think we will get there. There is hope. And Kenya is full of many brilliant people. So I don't think we are short of that at all.
Right. And maybe adopt Article 10 of the constitutional values to be the curriculum. So that right from the nursery school, we are teaching each other the values, and we continuously keep instilling the values within ourselves, the children, the adults, and even the aged. That's the direction I think we need to go.
I just want to add, as an educationist, it's very important what she said, values. You know, I think Kenya is one of the countries that we are really not patriotic enough. I studied both in the US and in the Philippines and even in Germany. They have their values well put in the lessons of the student. Every topic has an American value in it. Every topic that the teacher teaches has a Filipino value in it. If we grow with that, because nowadays the value we only have is to educate the brain, but we don't educate character. And when everything fails, character stands out. What is the character of the nation? Are we all people who say, kitu kidogo can buy you your whole country? Kitu kidogo can buy an election? Is corruption our second name, as we are put? Is integrity a problem to us or a sin to us? Or is it a virtue? And so those are, what she's raising is very, very important. When we were growing up, I believe many of us on this table had missionaries who taught us values, who taught us that if you find a pen there, you leave it there because it's not your own. But what do our lecturers teach? What do our teachers teach in the classroom? What do our leaders teach us?
Thank you.
Thank you.
Thank you very much, Anita. Thank you very much for, of course, your insight on that topic. Now we...